Good morning, everyone. Thank you for joining us today for our Fireside chat with Kieran Hart and Brendan Quinn. Before I hand over to Kieran, I want to encourage you all to use the question box or the chat function to raise any questions during the presentation, and we will address these during the Q&A session at the end. So without any further delay, I hand over to you, Kieran.
Thanks, Brigitte. So welcome, Brendan, and thank you for coming to our Fireside chat to mark the relaunch of our ADPO ICS Certified Data Protection Practitioner course. We're really looking forward to working with you on the course and helping to, help the students get the practical knowledge that they actually need. So in relation to your book, which is the Data Protection Implementation Guide, which I've read from cover to cover, it's an excellent book. And we've chosen it as the principal reference text for the course. And I know that your book in particular has really core strengths in, risk assessment, practical implementation strategies, the case law and analysis, the emerging technology and international data transfers. So it's really, really strong in all those areas. But what do you think yourself would be the benefits to the students on the course from this book?
Well, my book has been very well received, and I suppose it's been used quite a lot in actually training staff and training new entrants into the industry. Like many of the international law firms use it as a training manual for the staff when they enter work, and I suppose many of the multinationals themselves actually use it for training staff. But the book is divided into two halves. One half is on implementation. So it goes from everything, how to develop an inventory, to your gap analysis, to all the core topics within the GDPR. And the second half is essentially on the topics where, based on the first 3 or 4 years, I saw the regulators throughout Europe where they're actually enforcing it. And I suppose one of the things which kind of, the time I wrote the book, I was involved in a software compliance company, and the book was based on the methodologies I'd built up from doing GDPR work for a number of years. But it was also built up as well in terms of the experience I got building the software. But it was actually meant to complement a whole series of templates I had, because I had the whole GDPR reduced to a process. So the book was basically meant to be an explanation of those templates, which I actually mentioned in the book themselves. But the whole sort of idea here, when I was actually doing GDPR implementation work for large companies, I always wondered how were small and medium-sized companies going to manage this, because it's so complex, this law, for even big companies to do. And they had the same expectations were more expected of small and mid-sized companies. And this law looked like it was going to apply to every company. So what I did is I put together a book with all the core topics which I identified that every company would need to know about. And that was the idea behind it. So I dealt with like areas like children's data, employee data, third country transfers, AI, base rec, CCTV, the areas where there's a lot of complaints. And I suppose even though it's even like 3 years in, I don't think the book is actually dated in any way. In fact, it's probably more relevant because I covered 3 or 4 chapters of my book on AI because I had a background in AI, and I had a first-class master's level qualification in AI. And I've been doing work in that area before AI became a hot area with the release generative AI.
That's great, Brendan. Yeah, I certainly could see that from reading the book. It's almost like a book of two halves, which kind of the first half was GDPR and how to go about it, and then the second half was very much on what are the key topics of the area, including obviously AI. And
Yeah.
I'll actually move on to my next topic. So, and it's just a simple question, why do you think training is important? And what kind of issues do you think that the relaunched ADPO ICS Data Protection Practitioner course will help resolve for students?
I think whether you work as a data protection officer or whether you work in a company, everyone needs to know a little bit about GDPR, because, like, I suppose even from the point of view of exercising your own rights, it will give you that knowledge. But also in terms of protecting your company, because, for example, if a data subject wants to exercise one of their rights, and they can do that to anyone in the company. So all employees in the company need to have a certain level of GDPR literacy, so they can actually identify if they've actually received a SARS or if they've received an erasure request, because it's these simple things which will attract attention of regulators and get companies in trouble. And nobody wants their company to get into trouble. So, but I've looked at the course outline for the practitioner course, and it covers all the bases that people would need to know of the law. And then I suppose my book will provide a user-friendly way to actually understand all the core topics and the areas where regulators enforce on a daily basis.
Yeah, and you've just mentioned there actually, how user-friendly your book is, and it's very clear. It really sets things out. But how did you actually go about doing that? I mean, how did you actually be able to expand all the issues and all the rest of it, and actually keep it user-friendly at the same time?
I think the reason why it's user-friendly is I actually had a good understanding of the law, and I've been doing it a long time, and I think that helped quite a bit. So I think books can be confusing, if the author doesn't fully understand the topic, because you could write a book on GDPR based on a text, but to actually there's a step up when you actually have to understand the law. And if you can make someone communicate it well and help people understand the law, that's all to do with my understanding of the topics and the key topics, and the fact that I've quite a lot of practical experience implementing the GDPR through projects.
Yeah, thanks, Brendan. So we ourselves at ADPO actually try to make sure that our course, which we're relaunching, the data protection practitioner course, has actually been designed to combine the essential theoretical knowledge, including Irish and European law, with practical case studies. So this is to help the students to effectively implement data protection measures in their own organizations, but at the same time remaining compliant with the current legislation. So why do you think this is actually important, and what benefits do you think the participants will actually get from attending our course?
Um, I suppose the benefits that any course participant is going to get they're going to get understanding of all the core areas. So I've looked at the course outline, and it's a good broad course which covers all the key topics. And I suppose and a whole sort of things then people would then need to build on their knowledge through practical experience. But the important thing is to have a base in which to build.
Yeah, that is important. Yeah, so that the case studies and making it real. And
Yeah.
I think you attempt to
Yeah.
do that in your book. How did it can be a very dry topic. Some of the topics can be very dry, and it's actually make them come to life, as it were, and actually making it real
Yeah.
for participants.
I picked what I thought were the ones which I thought were the most interesting, because I suppose this law is still evolving. There's a lot of cases before the CU. A lot of the law hasn't been fully clarified. So I picked from all the regulators and the prior law what I thought were the most pertinent case studies to adopt, whether that was CGU cases, courts of the European Court on Human Rights, whether they're national courts or whether they were regulated decisions. Because the aim of this book wasn't to be a law book, it was to be an implementation book to give people practical examples of best practice and to discuss some of the issues. Because frequently in the beginning, you found that the regulators would adopt completely different interpretation of the same provision. So it's to kind of get some sort of common understanding of through the case of how these issues were being viewed, so companies could actually implement it. Because even one of the things I would have found when I was doing a lot of GDPR implementations, you'd find one one unit in the company could be doing it an implementation one way in one country, and could do it completely opposite way in another unit of the company. And it was those kind of things. Like, I think just the way that GDPR adopted this kind of risk-based framework, um, the way this kind of it allowed a lot of scopes to companies to interpret themselves. And there's still a lot of provisions in GDPR which need to be um, fleshed out and better understood. And now we have a whole load of series of other laws which are kind of doing that. They're adopting more specific provisions. So the way I see the GDPR is kind of evolving. It's kind of like GDPR is a generalist law which you fall back on when nothing else applies. And that's kind of very much how this is and then you've all these very specific laws which are coming out, like the Digital Services Act, the AI Act. They all sit in the frame, but ultimately the fallback law is going to be the GDPR, because the right to data protection is enshrined in the EU Charter of Fundamental Rights.
Absolutely, yeah. So it's I suppose that no law is in isolation, that it is actually affected by
Yeah.
other laws, and the kind of there's a cross effect between them all, and actually being aware of it and what you actually do, which is the real benefit of actually your book, because you actually did that, and you explain, you know, why these things were important, what you actually need to do, and you actually, you know, rather than simply setting out what the problems were, you actually set out what the problem was, but actually how you could actually resolve it.
Yes, yes.
And as I said, I think we said previously, you know, that you have taken a practical approach to data protection, and you actually give really good explanations, you know, of the high risk technology and their data protection implications, including many of the current focuses in the industry, including employer rights and surveillance, artificial intelligence and machine learning, and biometrics and facial recognition. So these are the issues that you focused on at the time. And I suppose the question would be is, why did you actually focus on those at the time? And if you're doing it now, what would you focus on now?
I think at the time, like, I was looking, I suppose it's not like now. Like, now there's a tsunami of guidance and case law, but at that particular time it was very easy to spot what the trends are and what regulators wanted to focus on. So I included the topics which I saw as the emerging concerns of regulators, which was the rollout of biometrics. Even though there was all these provisions in the GDPR to regulate biometrics, companies were basically implementing biometrics, and in a lot of cases without putting appropriate safeguards in place. And I could see this was an emerging concern of regulators in some of the European DPAs, like particularly countries like Germany and the Netherlands. So I focused on facial recognition. There was a lot of implementation going through at an EU level, particularly in relation to use in travel. So the fact that facial recognition was going to be used in travel and going to be used in shops was going to bring it into focus with regulators. And even areas like CCTV. I did a full chat because I know one of the old law, for example, in Ireland, I remember reading somewhere that about over 50% of all the complaints that went into to the data protection commissioners were in relation to the use of CCTV, which I found quite astonishing, that so many complaints were in relation to the use of CCTV. And the ways that CCTV was evolved, particularly during the pandemic, that if you you're trying to use it to capture people's temperatures, etc., when they're entering premises. So it's kind of the whole weight of, like, I picked out the topics which were going to be big issues. Like, third country transfers is still a big issue. Children's data, I did a full chapter on children's data, with the focus on the best interest of the child. So I kind of explained that. I did 3 chapters on employees, because I looked at all the books which are published in data protection, and none of the other books at that particular point in time covered anything to do with employee rights. Yeah, when I talked to companies, their biggest concern was actually how they're managing their employee data, and that was very little written on it. So, but the organization I'd worked for were in banking and financial services. And even under the directive, they would have had all these policies and they would have had the work done in relation to data protection for employees. And quite a lot of this hasn't really changed. But the thing is, a lot of the books which came out because they've been written by people who are newcomers in the industry didn't actually explain this. So I focus very much on AI because I saw it, and one of the, I suppose one of the things which is well for me, point of I had a background in AI and I had a background in software, so I could very much focus on my experience of building software. I could bring that to bear because even though I have a legal background, I also have the technology background as well. So I was able to bring in much more technology products, which other authors might be made to do because they didn't come from a technology background. They would have come from a legal background only.
Yeah, and I did notice that you had written a chapter in relation to AI and machine language. If you were writing that chapter now, what would you be saying?
Well, at the time, that I suppose there was talk about the AI Act, and I was very careful, not to actually, write anything on the AI Act because if I want, the idea I had it back in my head at some point I might write a book on AI, specifically on AI. So from my perspective, I was very, very careful in terms of what I wrote about AI. But if it's a writer today, there's been a number of cases from the CGU in relation to AI, and there's been more guidance. So I just add those in, but I wouldn't be able to focus too much on the AI Act. And if I do something in the future, I might do something in relation to a similar book in relation to the implementation of the AI Act because I'm involved in the standards for the AI Act. So I could probably add value there. But I suppose with all these things, the question is there demand for a book like that? Because I've seen myself personally with the AI Act that companies seem to want to do the stuff themselves. So I don't. So from my perspective, I would need to get involved in a number of AI Act projects, um, to actually build up the experience, be able to write that book.
Yeah, thanks, Brendan. Actually, I don't want to hog the conversation, so I'd invite all the attendees. Feel free to add in any questions, and we'll ask them of Brendan. But I do notice here the comment here from one of the participants said that you actually found your book really informative, and in particular, you found the chapter on employee data processing very, very helpful, which actually it was. It was really, really good. I suppose one of the questions going back to the course, like in terms of for the students, what do you think they should be concentrating on? What is really, really important? What do you think is really a hot topic in GDPR that the students would really need to know?
Well, the hot topic which everyone needs to know at the moment is AI, because like I even see myself, there's a lot more excitement about AI, and I suppose AI has brought GDPR very much into focus. There was a lot what I would call early stage technology companies that is actually and I suppose a number of decisions in relation to use of training data by the DPC has brought the whole area of their use of data into focus. So companies, so the number one concern of companies is going to be um, AI, and then of course as well as third country transfers, because at the moment we're waiting on a decision from the DPC in relation to transfers to China on TikTok. And we have to see what that says. And also there's also the current situation with the regime in the US as to whether that's going to have an impact on US EU transfers down the road. Because that was a hot topic a few years ago, and it could come a hot topic again. And another area where there's actually quite a lot of consensus as well is that there's a need to do something about protecting children online, and particularly around age assurance. So I think age assurance, people dealing with the processing of children's data, that's going to come a much bigger topic, because even though the US and the EU don't agree on everything, and China don't agree on anything, they all agree that they need to protect children. So that's going to become a bigger topic, and also as well, employee data could become a bigger issue because I say, for example, in Ireland with these tariffs, there could be layoffs down the road for companies, and when you have layoffs around that's going to cause a lot more public access requests by employees to find out data. If they're made redundant, they might want to put a public access to find out the reason why they were chosen for redundancy. So I see a lot of topics, but the things which are going to get companies in trouble are the simple things. So it's not responding to a SARS, not having a proper post in place to respond to SARS, not dealing with erasure requests, or not reporting a data breach. They're the things which are going to get companies into trouble.
Yeah, I have a question here actually, and you mentioned about international data transfers. The data privacy framework. Do you think that it will actually survive the Trump presidency?
That's a difficult question to answer because I think the CGU, when it went before saw the chaos which it caused. So they're likely to want to cause more problems if they can avoid it. But I even see there's like one of the things in relation to the framework there, and the Schrems 2 was in relation to surveillance. But now we have situation, another problem with relation to transfers is you have this different interpretation in terms of diversity between and discrimination between the EU and the US. And that's also people kind of think for some reason, some people think for some reason that GDPR is a privacy law or a data privacy law, but the GDPR in reality is a data protection law which applies to all rights. And one of those is the right to non-discrimination. So that's something which hasn't come in focus yet, but the whole situation around the difference between this rollback of diversity and inclusion in the US could lead to companies to actually look at whether they can actually transfer employee data to the US. And that's going to become particularly problematic for US multinationals who are operating in Ireland.
Yeah, we've another question here, and it was something I'm conscious of. It's the role of the DPO, and I have a question here from a participant. What do you think DPOs should be focusing on today, and how often should DPOs actually complete training? And I suppose it wouldn't just be, the DPOs themselves. It would be actually people who actually work with the DPO. What is your opinion of European data protection guidance? Is this something? Is the European guidance, should that be taken as written in stone, or should we just be focusing on the law?
Sorry, I didn't fully get that. You asked about 4 different questions in there.
Yeah. So in other words, in relation to the DPOs, I suppose starting off, what do you think DPOs should be focusing on today?
From my perspective, I suppose DPOs, they need to focus on the day-to-day work, which is sort of managing. Do they have any subject? Do they have any employee? Do they have any data subject rights request? And I suppose and data breach. So they're the core things. And I suppose if they've any other times, I suppose the other time they have is the areas which are going to it's currently a focus of regulators because it's a focus of the European Data Protection Board. Like I feel that one of the areas, and I see a lot of focus on myself, is the right to erasure. So making sure that they have proper process in place for the erasing data when there's a subject access request.
Absolutely. And just moving on to another area in relation to the DPO, and I suppose one of the experience that people have is that in relation to DPIAs, the standard of DPIAs can range from being excellent to could be improved. Have you do you have any advice, for how people as DPOs or people even assisting the DPOs, how they can encourage or actually raise standards for DPIA completion?
Yeah, I suppose this is always something that I've seen myself in companies that sometimes when a team is asked to produce a DPIA, they won't go ahead with a project. And I suppose it's one of those, and even there, the guidance from the Article 29, which came to European Data Protection Board, was very much focused on security. Whereas the guidance from the European Data Protection Group on the equivalent provision was focused on all fundamental rights. In terms of DPOs, I suppose the DPOs should make sure that they have the template to I suppose to share with the teams, and to allow them to actually be able to complete the template, and it shows they should be actively involved at each stage of the DPIA process to ensure that the DPIA is of a high quality, rather than focusing on the DPIA at the very end and just reviewing it and signing off on it. They should be involved in actually advising on an audit stage, and they should ask for regular updates and meet regularly with team members to ensure that it's of a high enough standard. Because when it was one of the things you have to understand, I suppose, when you deal with the data protection commissioners, the data protection commissioners rarely ask to see the DPIA. They see it as a tool for the internal use of companies, and it's there to protect the company reputation. Because it's and even there, if I was starting off projects today, if I knew what I knew now, I would probably be using the DPI much more in terms of building the inventory than I would in the past. Because once you have initial data protection program in place, the only stuff you should really be adding is the high risk stuff. And that should be captured in DPI. So you should be capturing what data, the controls, your internal controls in place, your safeguards. So I think the DPIA is going to come far more important. But frequently, I find myself is the DPO. A project might be starting, particularly in a large organization, and they mightn't actually be made aware of the project till late. So that means that the DPO doesn't get involved till the late stage, whereas they should be involved from the beginning. And that's a frequent issue as well. But this question is very, very difficult to answer, because I know myself, I've come across situations where teams within companies who, when they've been asked to do DPIA, have actually put the project on hold because they just want they'd see that as an extra thing to do.
Yeah, absolutely. And when you were writing your book and you consciously took a project management framework approach, in terms of implementing the key high risk areas and using case studies, from supervisory authority decisions, including our own Data Protection Commission, the European Court of Justice and the European Court of Human Rights, to illustrate and describe your approach. Now, and it's related, I suppose, to the DPI question that I actually asked as well. But what do you see as the benefits of actually taking this approach, to implementing GDPR, but actually implementing it now, 7 years on?
Yeah, well, what I suppose the company is ultimately a bundle of projects. So, and like I see the DPI, for example, as a tool for project management. Because and then you talk about, and then this whole concept of data protection design is kind of the enterprise view of a bundle of projects. So, and I've even seen there was a survey there on the European data protection. It's a group body for DPOs in Europe, and they identified that one of the key areas where DPOs need to up their skills are in relation to project management and also commercial knowledge. So there is an understanding there that project management skills are actually necessary for DPOs to have. as well as like all the other skills they have to have, like technical knowledge, communication skills. They have to have project management skills because, for example, the data protection impact assessment essentially is the project management tool. And as you're talking about the life cycle of a particular project, and the same thing there in relation to AI, like the kind of focus on a lot of DPIs will be on the rollout of AI, and the AI from the point of view it's a systems development life cycle. So that's a project as well. So if you don't understand project management, you're not going to be able to help understand and advise and mitigate the risks. So you need to understand the project life cycle and commercial realities of companies to be able to do your job properly. But from my perspective, in terms of DPOs, the biggest thing that I see now is just the tsunami of content in terms of guidance, case law. Nobody keep up on it, and I see the biggest risk of DPOs in the future is going to be burnout, because the amount of work they have to do and the amount of reading they have to do. Because at the time I wrote the book 3 or 4 years ago, I was relying on quite a lot of case law and a lot of decisions. But now there's some major change in data every week. And sometimes 2 or 3 times a week. There's guidance, there's case law, which impacts company every week, and companies just can't keep up with us. And the DP, and a lot of cases, particularly in small and mid-sized companies, if they have a DPO, like a small company could be half of someone's job, and even a mid-sized company, it could be a standalone role. And it's only the bigger companies which are going to have teams of people. So you're in a situation that the DPOs, it's not possible to keep up with the level of guidance, case law, and changes which are occurring on a weekly basis. And more DPOs are now getting responsibility for AI. And not the steep learning curve as well, because I have a master's level qualification in AI. And what's actually involved in generative AI, it probably involves the most complex areas of AI, which people even master's qualification would only touch on briefly because it's so complex. You're talking about DPOs who might have no technical IT background, are being asked to basically evaluate AI, which basically probably needs to actually understand the stuff properly, would require a PhD in a specialist AI field. And they're being asked to go out and evaluate this stuff. So that kind of indicates how difficult the job is for DPOs. And similarly, there's a whole range of other laws out there which fit in with the GDPR, particularly the AI Act. The AI Act is coming as well, and DPOs are probably going to have responsibility for that piece of legislation as well. So it's all coming very complex.
It is, and you've made an excellent segue to my next question. And one of the objectives of the current EU Commission is actually trying to simplify the agenda, in particular for SMEs, and that would include GDPR and AI. And I suppose one of the things about project management, and you'd know, one of the key aspects is actually trying to simplify it and trying to bundle the jobs into the same time slot, trying to make things more efficient, but also, doing value trees in terms of which is the best material, for the job that you're actually doing, all with the aim of actually trying to simplify the job. So in relation to, I suppose, GDPR in particular and in a related aspect, AI, if you were asked to simplify it, what would you do?
Simplify AI or the GDPR?
Both, in terms of what is being expected of SMEs.
Yeah. Well, I've kind of felt that this should be done. I think the guidance which comes out of regulations is not fit for purpose because none of them have actually implemented GDPR, but they should actually be able to do this as a process to help companies, and they should provide more templates to companies in terms of how they actually implement this stuff in practice. And they should provide much more what I would call video content for companies. And the way they should approach this, and I suppose is the way they should approach this for smaller companies is they should just focus on the higher risk areas, and that's the way the GDPR has been formulated. You don't have to do deep GDPR work for everything. Like, it's a risk-based approach. So the way it is at the moment, you have to implement the data protection rights, and be very difficult for the European Commission to scale back on the rights of the data subject related to erasure and rights of access, because that's contained in Article 8 of the EU Charter. So the only ways they can actually scale this back is in relation to the paperwork, in relation to areas like third country transfers, have a more simplified DPIA based on a template. They could probably, I suppose, most small companies won't have to have a DPO anyway. So in reality, in a lot of cases, it's going to be quite difficult to scale this back. I suppose what they do is they'd have to take position in terms of what they expect companies to do, provide more support in terms of tools to enable them to actually be able to do this work. And it's supposed to be, when they're actually dealing with them, to adopt a more helpful rather than confrontational approach, which I suppose I see myself in the DPC. The DPC is loath to actually enforce unless they need to. They want to try and manage things in an amicable fashion, and adopt an amicable resolution. But one of the things I find is as well is you find even things where the DPC has actually had decisions on in relation to, say, asking for official use documentation. There's still a lot of companies are still asking for photographic ID, even though the DPC, I think, have had 3 decisions saying you shouldn't be asking for photographic ID unless there's a reason to do so. And there's still quite a few companies out there, big companies, still asking for this. And also as well, the DPC 3 years ago had a binding decision in relation to WhatsApp, which was binding on them. And there's still loads of companies out there who haven't even updated their data protection notices. So when they talk about all these concerns for SMEs, I don't, even big companies haven't updated this stuff. So I think this is it's more a case companies don't want to do this stuff because it's a cost, But at the same time, looking myself, I think there's very few ways to actually simplify the GDPR apart from reduce some of the paperwork and particularly in relation to international transfers. And some of the stuff is, like, at the end of the day, if a transfer is made to the US and US law enforcement want to access this, they're going to access whether you have paperwork in place anyway. So in a way, this doesn't really make sense to have all this paperwork. Yeah, and that's kind of my, and then similar to the AI Act, a lot of companies don't really fall in scope under the AI Act, because if they're not falling in a high risk or prohibited category, the only real obligation on them is really related to transparency, or if they're or in terms of how to use generative AI. So for the average companies, there's not much work to do for the rollout of AI. And even there, in relation to a lot of the high risk use cases, that's actually beneficial to companies, because I find myself, I've come across companies outside the Eurozone who haven't brought their products, say, for example, on facial recognition or biometrics into the EU because of the compliance involved. But the AI Act provides them with a template and basically tells them what they need to do in terms of making their product compliant with EU law. Because currently under GDPR, there's no standards, there's no what do they call them? There's only one certification, So it's very difficult for companies to understand what they need to do to make their products compliant for AI and bring them into the EU. And I think the AI Act provides a bit of more certainty in terms of that for high risk products, AI products. But
Yeah,
it is a lot of work. But
yeah,
at the
there's
same
a
time
lot.
there, but at the same time there, there's nothing wrong with standards because like suppose companies want to make shortcuts, take shortcuts. But at the end of the day, this is about protecting people, protecting society, because we could end up in a situation where, which we have currently in relation to, say, our food chain, where a lot of our people now realize a lot of our food, which is on sale now, is full of additives, which might be causing health problems. And if we adopt a light touch approach with AI, we could end up in a similar situation.
Yeah, and as you mentioned, there are standards. The big advantage with standards is they actually provide certainty. That when you have a standard, you know exactly where you stand. You know exactly what it is that you do, and that's where the benefit of codes of practice come in, and certification as well. Um, it seems surprising, that the certification, that there has been so little take up of that. Why do you think that would be? Is it because it's very complicated?
Um, I presume it's because companies haven't seen a need for it. Like one area I have seen that, and there was an attempt to ICT Ireland to develop a certification related to use of children's data, but I saw that for years, and I don't know what's become of that.
Mm.
And there's also a certification as well. Uh, it was Euro privacy or something like that, and I don't hear much about what the take of that is like. Um, but I think, but initially beginning, there's a lot of focus now on data breaches and the rights of a data subject, and you don't and standards and certifications aren't useful for that.
Yeah, I actually there's a question in the chat in relation to data breaches, and um, this is from many DPOs use the ANISA data breach methodology for assessing risk in breaches. Have you come across any comparable or better methodologies to that?
No, the Enza one was around for, I suppose, a time I was doing GDPR implementation. I haven't seen any since then. I haven't seen any comparable ones since then.
Yeah, yeah, very good.
So
Okay.
that's kind of the only one which I've seen out there, and I suppose it's widely used.
Yeah, yeah. But I suppose going back to the risks, particularly for SMEs, um, where SMEs or companies are developing a data protection risk register, you know, um, how would you suggest going about it, and what do you think should actually be included in it?
Yeah, yeah. Well, I suppose this is something I went into quite a lot of detail in my book, and I suppose really, I suppose the way I kind of approach this is you kind of take what I would call the the process for records of processing, and you add more columns there, and you put more information in terms of the technical controls there. But the kind of way to kind of approach this is kind of look at what's written in recital 75 and 85. So that identifies what the high risk are. So you kind of look at what data you hold, where you hold it, and if it was eventual that there was any kind of is there risk of, say, identity theft, fraud, damage to reputation, discrimination. You look at any of these risks, physical harm, financial harm, and look at data you hold, and then put that together and put together risk and what mitigants you have in place. So then kind of look how secure you are in terms of the controls you place and whether that's actually mitigate the risk. There's quite a lot of complexity involved, and I think this has to be tailored to the organization. But the way I've kind of done the class is I focus on the inventory, which is basically what's in the records of processing, but extra columns. But also I add an extra columns in relation to the high risk, which I mentioned, Article or in recital 75 and 85. So I kind of focus on there and what data is held and what mitigates in place and how you actually reduce those risks and put controls in place. Because at the end of the day, you can't kind of cover everything. So you can only focus on the high risk, and the regulators don't expect you to focus on everything. They just want to see that you've got a thought process in place, and in relation to areas where there is actually a high risk, that you actually have appropriate safeguards in place.
Okay, on a related issue in relation to data transfers and in relation to the standard contractual clauses, do you think they're actually sufficient for transfers, not just the United States, but to India and China and other countries?
Um, I personally, I don't know what if there's really much value in putting together paper-based controls. I think it's kind of case if you should do it. I suppose it's at the end of the day, it's about um case by case basis. If you have a bit of common sense, you should be identify if there's a risk of making particular data transfer, and that shouldn't be done. And 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 a lot of cases is technical control. But say, for example, if China wants to access your data, if America wants to access your data, and you're some way a problematic person, they're going to do so anyway. So whether that data is held in Europe or whether it's held in the US or no matter what it's held, they're going to want to have access to it. And then like there are some countries who are like India, which doesn't have adequacy, even though they have a data protection law.
Mm,
Like a lot of transfers to India, I would see as high risk.
mm,
But at the same time, there are regulators seriously going to want to go around and say you can't transfer this data to India and cause chaos.
yeah,
And,
yeah.
and I don't think they want to do so. And even there, for
Mm,
example, in relation to the CEG ruling in Schrems 2, like there were certain regulators who actually said they were not going to enforce Schrems 2, even though it was legally binding on them. And
I
even
think
our own DPC here, um, I know myself from my experience, they don't really want to look at third country transfer complaints.
yeah, you actually mentioned the specific example of Luxembourg in your
Yeah,
book in relation to um, implementation of Schrems 2. Yeah,
yeah.
absolutely.
I know the Polish DPA, the customer or custom company I dealt with, said they weren't going to implement Schrems 2. They weren't going to look at any third country transfers. And even the ICO, under Elizabeth Denham, um, she had said at a number of conferences that she wished that she can get all these complaints from each third country because she wanted to focus in areas like children's data protection, which she saw as a bigger issue. But she
Mm,
had to focus on the complaints she was getting in.
mm,
And you even see that in relation to the prohibited practice under the AI Act. All those prohibited practices are all um, infringing of the GDPR. But there's been no decisions on virtually any of those decisions in relation, or the only one in relation to web scraping for facial recognition. There's been no decisions in any of those areas. So,
mm,
so in reality, what happens is consumer rights groups and these activists put in complaints about matters, but they're not matters that European Commission really wants to focus on. Um, and you can see examples of the prohibited practice in the Act. That's the kind of stuff that the Commission wants to see banned, wants to see tackled by the GDPR, but it wasn't.
mm.
So in reality, what you've actually ended up is complaints have focused on things that are problems, but they're not the biggest problems. But they have been the focus of they've been the focus of activists, and those complaints go into DPAs.
Yeah. Okay. That's
Because
great.
even you see it yourself in relation to the DPAs only have limited role, and yet you see a number of activists all the time playing that they won't handle their complaints in relation to things like say
Mm,
people showing ads. I can go into my browser and I can block seeing all ads.
Mm.
You know, and so at the end of the day, if I'm able to do, why can't other people do it?
Mm.
You know what I mean? And if they want to stop using all this data, and then you have the likes of Meta in relation to the use of personalized data in ads. Um, like, you know, after years and years of fighting with Meta, um, all the vendors end up with is consent or pay.
Yeah. Yeah. Okay. So I'm going to go back to the chat and look for questions, but I'm looking at I suppose, the burden on DPOs and what it is that's expected of them. But I suppose one question would be, how often do you think DPOs should complete training, and would our course be suitable for training large groups in companies?
Yeah, yeah. What is? Yeah. Well, I suppose there's no mandatory requirement for every company to be trained in GDPR, but companies who have a DPO, there's a requirement in those sort of companies um for employees to be trained. But at the same time, there's no one size fits all approach. But the advantage of training like the ADPO provides is it provides a basis of knowledge for people of the basics, because everyone needs to know a little bit about GDPR because it applies to all companies. So everyone in the company needs to know about um, and what is a data breach, because they need to be so to make sure that, for example, that they don't send the email to an incorrect person. They don't send posts out to someone who's deceased. They don't, if they get a SAR, that they know that the SAR has to be transferred to the pro person, whether that's a compliance officer or DPO. They know that people have a right to erasure. So they need, everyone needs to have the basics of GDPR, so they know how to respond to requests from individuals. Because ultimately, at the end of the day, most complaints which actually go in are basically in relation to an underlying issue, which is basically how the customer or an employee has been treated and they're not happy with it. And then they weaponize the SAR. So from my perspective, everyone needs to know the basics of GDPR. So that needs to know things like having a lawful basis, how to correctly manage data. For example, that they shouldn't walk out of the office and leave sensitive files lying their desk. They shouldn't throw sensitive documents in, for example, in a bin where there's been a number of files. If they're dealing with special category data, that they should handle it better. Because ultimately, at the end of the day, the whole idea behind this is the history of the excessive use of IT and how it can be used to impact on people's rights. And this is about respecting individuals. And from my perspective, everyone should should understand the basics of the GDPR, but it's only a legal requirement to actually have sure staff is actually trained when a DPO has been appointed. For other organizations, they probably have to have, they probably should have training, but it's not actually mandatory.
Yeah, yeah. I certainly would be advisable to have training so they don't
Yeah, so
run themselves
the
into bigger problems down the line. Yeah, absolutely.
Yeah. But I
Yeah,
suppose the DPO can handle the training, or this can be transferred to an external training provider.
yeah,
And
absolutely.
I suppose I've looked at the ADPO, and it provides a good basic understanding of the key provisions in the GDPR. And then I suppose, and then my book contains the information in terms of the areas where they're actually the regulators are actually enforced in practice. So the areas which are most relevant then to companies as well, they can focus on those areas much more in my book.
Yeah, and getting back now to your book, and I've got a two-parter, I suppose. I mean, how long did it actually take for you to write the book? That's the first question. And the second question then is, will you be writing a revised and updated edition to the book? And if you are, what would you expect to include in the new edition?
Yeah. Yeah, the original book was actually, I suppose, see, I had a manual which I put together from the work I'd done. So that manual was kind of expanded and it was expanded basically during the COVID-19 lockdown. So essentially, the book was written during the two times where you weren't basically allowed to leave your house. So it was, and one of so it was actually written more or less in about 3 months, but it was written under a time that there was very few distractions.
Mm.
But it's very different today because there's a tsunami of content and there's so many cases and I suppose it's really how to bring how to bring information into a book because if you make the book too large the publisher will charge more.
Mm.
So it's how to make the book compact and to make sure that the all the most relevant information is in it because if I was to expand the book, um, based on what's come out since then, I could easily add another 200 pages to it. But if I added 200 pages to it, the cost is going to go up a lot from the publisher. They're going to charge an awful lot more, and that's going to turn off that's going to turn off people wanting to buy it.
Yeah, and read it as well.
Yeah, and I find they say people nowadays, because of all the scrolling doing on, they don't really want to read books. They scan books. They don't. People are reading so much stuff on social media and online.
Yeah.
And this whole GDPR thing, there's so much content coming out of it. You
Mm.
can't possibly read it.
Yeah,
So at least it's like a book like I'm doing is how I've actually seen it being used. It's been used as a training people who are new entrants into companies, whether or law firms.
Mm.
But a lot of DPOs are using it to train their staff. So they're using it to develop training for staff. And and then quite a lot of companies are already at an advanced stage. They're not going to be starting from scratch. So it's really hard to know what I do because I have been advised to make it much more implementation orientated and move the case law. But it's very hard to know what to do because there has been no feedback. That's one thing I'm hoping to get off this course is that if more people in this course are using it, I can get feedback in terms of what worked and what doesn't
Yeah.
work. So that
Yeah.
but the book was successful enough that the publishers asked me to do a second edition.
Yeah.
But one of the things I've held of doing because I want to see how they I suppose as you know just you know Commissioner McGrath is going to look at simplifying the GDPR. So there's no point me bringing out a new edition, until there's some sort of idea in terms of what that looks like. Because
Yeah.
I could bring a book out that's immediately obsolete. Because I saw there even about a month ago on LinkedIn that somebody brought out a book on the privacy regulation. That's been scrapped. So,
Yeah.
so it's very hard to bring it to write something until there's some sort of level of certainty. And then there's a lot of uncertainty as well about the current administration in the US because one of the things I've seen, they've adopted this extraterritorial approach to diversity and inclusion, similar to what the EU have done with laws like the GDPR and the A Act. So this could be part of a bargaining position that it could be far more revisions to the GDPR than we might envisage, but it's just not clear. But the thing is,
Yeah.
because the right to data protection is enshrined in the EU Charter of Fundamental Rights,
Mm.
they will never, it will always be there. But it's a question of what form it's going to take.
That's great. Thank you very much, Brendan, and thank you to all the participants
Okay,
for
thanks a million.
coming
Yeah.
today. I wasn't able to get to all the questions, so if you have any questions, feel free to email them to info@ics.ie, and Brigitte will pass them on. So I'd like to thank Brigitte as well for helping with the hosting of this webinar today, and obviously Brendan for coming in and talking to us